In this video, we're going to talk about how to properly evaluate a non-permanent resident alien. And the guidelines in the agencies are very limited. I'm not going to go through all of the guidebooks right here, but I will show you the Fannie Mae requirement. So it says Fannie Mae purchases and securitizes mortgages made to non-U.S. citizens who are lawful permanent or non-permanent residents of the United States under the same terms that are available to U.S. citizens. Now, Fannie Mae does not specify the precise documentation the lender must obtain to verify that a non-U.S. citizen borrower is legally present in the United States. The lender must make a determination of the non-U.S. citizen status based on the circumstances of the individual case, using documentation it deems appropriate. By delivering the mortgage to Fannie Mae, the lender represents and warrants that the non-U.S. citizen borrower is legally present in this country. So there are tons of different kinds of visas. There are many different kinds of employment authorization documents. And so if you had a newer loan officer who was training on the Complete 1003 program, when they got down to question 13, non-permanent resident alien would be one of the selections, just like it is on the 1003, U.S. citizen, permanent resident alien, or non-permanent resident alien. So for non-permanent resident alien, I'm going to show you the questions that they would need to ask so that they can at least gather all the information and documentation that's necessary in one attempt. Then they can start to work with their processor or underwriter and determine if the individual applicant's circumstances meet your company's requirements. So first in 13A, the non-permanent resident alien can either be working with a Social Security number or an ITN number. And we give you some guidance here that an ITIN number always starts with 9 and has 7 or 8 in the fourth position. Now, does the borrower have a legal right to work in the USA? And if they do, the legal right to work is evidenced through, is it through a visa only, an employment authorization document only, or in this case, we're going to say a visa and an employment authorization document. So the start date of the visa was when, and the end date was when. Has it been previously renewed? In this case, we're going to say it has not been previously renewed. Here's the type of employment authorization document. Is there a start date and the end date to that? Has it been previously renewed? If the answer is yes, then we'll have a little box here for the MLO to know to capture the information that it's been extended once from the original 2-year term. And then in 13L, was this employment authorization document issued under DACA? Because some lenders have been getting closing loans and the EAD was issued under DACA, but the documentation isn't always clear that that's the case. And not making a moral statement here, but sometimes lenders did not intend to close those loans and they ended up having them on their books. So are there any pending or new or renewal EAD documentation applications? I'm saying does not. Any pending visa applications, either a renewal of an existing visa or an application for a different visa type. And then to ask the applicant, is there anything else that you'd like to tell us about your residency status, including if you're in the country under an I-551 stamp to prove your permanent resident status while you await the generation of your green card? Or if you have an expiring or expired green card and you have a notice from USCIS that extends your authorization to work in the United States while your Form I-751 application to remove conditions on your residency is pending. And this last question here is one that also would have activated if they were not yet a permanent resident alien, but they were in the process of becoming it. And then we give some guidelines. We say these are for internal use only. They're a combination of actual agency guidelines and general advice as to how to properly evaluate this applicant. Now, we don't necessarily include the advice for every single agency under each question. We want to make this very detailed and thorough, but not 5,000 pages cut and paste of all regs. So here we give 4 warnings or guidances. That first is your borrower must have a valid social security number or ITN. And Fannie and Freddie say their visa may not expire within the next 3 years, as most visas are issued for less than 3 years. Underwriters usually want to see that the visa has been extended once. However, if your borrower has an EAD, that may be sufficient, regardless of whether or not the visa has ever been renewed. Unexpired H-1 visas are an exception and are usually allowed by Fannie and Freddie underwriters even during their first issue period. And then FHA only requires that a borrower can live and work legally in the USA, so a green card is not necessary. A visa and social security card is enough. However, if your company requires a visa, make sure the type and duration of the applicant's visa is acceptable. In practice, many FHA underwriters will require that the visa has been extended one time because it's difficult to get a government agency to comment on the likelihood of renewal. A letter from their employer stating that the job will continue and that they will support their employees' visa extension may be enough. And this could also help on a conventional loan. And again, an EAD may take care of this issue on its own. Now, VA does allow a non-permanent resident alien to be a co-borrower with a U.S. citizen veteran, but they don't offer any guidance in determining their eligibility. The non-permanent resident alien cannot become a veteran, but VA does allow them to be a co-borrower. And our last guidance on this subject is to make sure that the employer matches the employer listed on all work-related documents. Also be aware that the work status stamped on a Social Security card is not necessarily current, so you may need to rely on the status shown on the U.S. Customs and Immigration Services form. Also, it's not likely for a borrower not subject to U.S. jurisdiction, such as someone with diplomatic immunity, to qualify for agency financing. So these are the questions that you need to ask if you're working with a non-permanent resident alien, to gather all the documents and all the information in one swoop to make it easier on yourself, on your team, and also a smoother experience for your borrower.